and other people can join. So first of all, who am I? My name is Nathan Holden. I lead Free's local government practice, and one of the areas that I specialise in is making and promoting compulsory purchase orders, which I've been doing for the last 25 years, both in-house and externally. And the world over that period has changed quite considerably in terms of what's involved. So anyway, without further ado, I'll explain what I'm going to be talking about in the next hour, possibly slightly longer than that, hour and a half. I think it's scheduled for an hour and a half. I think I'll probably talk for about an hour and 10 minutes, and then there'll be some scope for asking some questions at the end or as we go along. So what are we going to be talking about? Well, today we're talking about making and promoting compulsory purchase orders. And I've described this as section 1 about getting your ducks in a row. And this is really all about some of the preparatory steps that you need to take if you're, as a public body, a local authority, looking to make a compulsory purchase order. Selecting the power, which relevant councils are creatures of statute. They've got to rely on statutory powers in order to make compulsory purchase orders. So identifying the correct power is very important. The compelling case test, that's the central requirement for any compulsory purchase order, that you can demonstrate there's a compelling case in the public interest for the CPO to be made. And then look at some key areas of focus, talk a little bit about preparing for the inquiry, what that means, what steps you need to follow, and then finally talk about what happens after the inquiry, and we get to confirmation and implementation. So in terms of the different steps that you need to take, the first thing I think needs to be emphasized is that making and promoting compulsory purchase orders is not a speedy process. It by and large takes anything between 12 and 18 months. If there's an inquiry, 18 months. If there is no inquiry, a bit less. The process has got a little bit quicker in the last few years because up until then, all compulsory purchase orders had to be confirmed by the Secretary of State, or rather an official working for typically the Ministry of Housing, Communities and Local Government. That role has, to an extent, especially in the context of planning CPOs made under Section 226 of the Town and Country Planning Act 1990, has been delegated to planning inspectors. And what this means is that historically what would happen is there would be a compulsory purchase order inquiry because there had been objections to the confirmation of the CPO. An inspector would conduct an inquiry, write a report, and then send that report to the Secretary of State. And then someone in the government department would then review the whole of the case and all of the evidence presented, and the inspector's recommendations, and then determine whether or not to make a CPO. What happens now in the vast majority of cases, other than very large cases or politically complex cases, an inspector, planning inspector, will perform that role. He will consider, or they will consider, or conduct an inquiry, and then make a decision on the back of that. And that reduces the amount of time quite considerably, especially as inspectors are under pressure to produce their decision within, I think it's a month in 80% of cases, after the inquiry closes. Whereas historically, you'd probably be waiting as much as 3 or 4 months before you had a decision made, sometimes as much as 6. So that's helped to make things a lot quicker. But what isn't very quick these days is the process. So the way in which the confirmation of compulsory purchase orders is managed by the planning casework unit, who are responsible for dealing with compulsory purchase orders predominantly made by local authorities, Planning Act 1's housing. That administrative process seems to take a lot longer than it did. So where you've gained in terms of the decision-making process, you seem to have lost a little bit in terms of the administration of the confirmation process. That seems to have got slower. So anyway, what are the steps to making a compulsory purchase order or promoting a compulsory purchase order? Well, first of all, you need to formulate why it is you want to make a compulsory purchase order. Determine that you need to make a compulsory purchase order, I suppose, is the main point. And then you need to resolve to make a compulsory purchase order, because it's a decision of an authority, like to acquire land on a compulsory basis. You then, as a public body, you make the compulsory purchase order. Now, the order doesn't come into effect once it's made, because it needs to be confirmed. And in order to be confirmed, it must be referred to the Secretary of State. And that process involves inviting objections. Give people an opportunity who wish to assert that there's no just reason for making the CPO, or that the statutory criteria hasn't been met, or that there's good grounds for suggesting that there are other reasons why it shouldn't be confirmed. Objectors have a right to object to the CPO. If there are valid objections to the confirmation of the compulsory purchase order, and emphasise its confirmation at this stage, local authorities made the order, Secretary confirms it. If there are objections to the confirmation of the order, then there needs to be some means by which those are resolved, and that is resolved by virtue of holding some form of inquiry. An inquiry will occur in the majority of cases where there are valid objections. I say valid objections because only objections that relate to the basis on which the compulsory purchase order is made will be valid. Objections that relate purely to compensation issues are not valid, because they don't relate to the principle upon which the compulsory purchase order is being made. Issues of compensation are dealt with entirely separately in the compulsory purchase system. The principle based on which they're ultimately resolved is through the upper tribunal lands chamber. So you have an inquiry to consider the objections, and an inquiry, there will be live evidence unless it's dealt with by written representations, which is an option, but not one that's taken very much. There'll be a full inquiry, a bit like a planning inquiry, where the acquiring authority, the council, will have to put its case and explain why it wants the compulsory purchase order to be made, and adduce evidence by calling witnesses, who then can be cross-examined by objectors and the inspector. And then following that, the objectors give their evidence. They can be cross-examined by the acquiring authority, and then they are able to, and then finally the acquiring authority sums up the case, and then a decision is made. And the decision in those circumstances will be either to make the order, confirm the order, or indeed it might be to confirm it with conditions, or it could be to confirm it and take certain plots out of the order, or alternatively it may be not to confirm it at all. So a decision of some description is made. Vast majority of decisions, I think it's as much as 70 or 80% of all compulsory purchase orders are confirmed, according to statistics. So on the basis that the compulsory purchase order is confirmed, that will be the decision. The decision then is published. There's a judicial review challenge period, and assuming there is no challenge made during the statutory challenge or judicial review challenge period, then the authority can go on and implement the CPO. And implementation is the final stage in the compulsory purchase process. So at this stage, the local authority has the power to proceed with the CPO because it's made a compulsory purchase order. It's been confirmed by the Secretary of State, and now it then goes on to use one of two different processes typically to implement the CPO, i.e. take steps to actually acquire the interest, or indeed take occupation of the land that is needed for the scheme or development, and later agreeing to transfer it once compensation is paid. They're the principal two bases upon which the CPO is finally implemented. And then, of course, once it's implemented and land is acquired, the final stage in the process is compensation. And as I say, compensation is not a matter of any relevance. Final stage. and because in practice the entitlement to compensation is only triggered once a compulsory purchase order is implemented and land is either acquired compulsorily or occupied, or entry is effected in respect of that land. At that point, the entitlement to compensation arises. No compensation will be payable at any stage in this process until a compulsory purchase order is implemented, or alternatively, if a compulsory purchase order is made and the landowner serves a blight notice, which in effect is a form of reverse compulsory purchase. The acquiring authority effectively is then required to purchase the land, and that then gives rise in effect to a compensation payment. But other than in those circumstances, up until the implementation stage, there is no jeopardy in practice that the landowner suffers. And in fact, indeed, authority could choose not to implement the CPO if it decided it didn't want to, albeit though it would always run the risk of a blight notice being served and therefore being forced to acquire. Although, by and large, that's quite a rare thing to happen. It doesn't happen very often that blight notices are served, but it's worth emphasising that that is pretty much the only basis on which you can force a local authority to acquire land where a compulsory purchase order has been made. Note this is made, not confirmed. So in fact, it comes in right at the beginning of the process. So once an order has been made and awaits confirmation, then at that stage, there is a very clear and potential risk of a blight notice being served. So the next slide really is to talk about whose help you need and why, if you're in the process of looking to promote a compulsory purchase order. What kind of skills and expertise will you need as a local authority in order to promote a compulsory purchase order? Now, the first point to make, which I make quite rigorously, is that it's very, very important to have a significant degree of internal buy-in to the making and promoting of compulsory purchase orders. Even where a local authority is assisting, say, a private sector developer to assemble land for some form of scheme, it is still the council that is making the compulsory purchase order. It is still the council that is responsible for that order, notwithstanding it may be that the developer is paying for it via some form of indemnity agreement. It'll still be the council that will probably need to call witnesses at an inquiry. And if they're going to call witnesses, then they'll need to arrange for those witnesses to prepare evidence. That evidence has to dovetail with evidence of other witnesses. So it's a very lengthy and drawn out and detailed process. And it's a huge commitment. I don't think people fully appreciate how forensic some of the cross-examination can be in at an inquiry for a compulsory purchase order. So therefore, I think it comes as something of a shock sometimes for those who are involved. So initially they think, yes, happy to be party to this, happy to give evidence at an inquiry, but don't fully understand quite how tested they were likely to be. So as I say, you really do need significant buy-in. If you're making a planning CPO, then you want to promote a planning CPO, then you're going to need someone to give planning evidence. You're likely to need someone to give some kind of strategic overview evidence. And you're also likely to need a surveyor, external, internal, who's been through the negotiating process. And you'll also need, as I say, possibly other disciplines as well. So you're looking at probably as many as 5 witnesses who will need to give evidence. And before you get there, you need to produce a statement of case. You'll need to produce a statement of reasons. There's lots of documents to complete. It is an onerous exercise and not one to be taken on lightly. Who else are you going to need to assist you? Well, if it's a scheme that involves probably more than a couple of property interests, you're probably going to need a referencing agent. And you'll say, well, what's a referencing agent? A referencing agent is a company that will assist you in putting together certain of the documents you need to promote a compulsory purchase order. They'll assist you in putting together the schedule to the order, which effectively is a list of all of the interests you're seeking to acquire, and there's a prescribed form for what that looks like, and I'll be talking a bit about that later. They'll also put together a map, which again is in a prescribed form, which will identify the land by showing it shaded pink, outlined in red on a plan, to a scale of a minimum of 1,000 to 1 to 1250 scale, and also it'll indicate land that the authority simply wishes to acquire rights over. Now, there are a number of private sector companies who provide these sorts of services, and I identify a couple of them. Ardent, probably one of the biggest now, Terracrest, one of the older, well-established organisations, and LRS, and I've dealt with Gately Hamer as well, who do it. So I'm not promoting any of those. There are others. I think Countrywide also do it as well. But they are useful if you have lots of plots, and they are very good at understanding how to put the documents together, and they're very good at doing the kind of desktop research in relation to title and ensuring that all the relevant interests are picked up. My only possible criticism of them is they do take a bit of a kind of a very blunt approach, which is they tend to want to acquire everything and all interests, and they're not very discerning. So they do tend to produce incredibly long and lengthy schedules of interest, which may not be necessary, because it may be that all of the interests are not needed to be acquired, but they do take a bit of a sledgehammer to crack a nut approach. So that'd be my only criticism. As I say, you'll need a surveyor. That could be somebody that's internal or external. That's important because, of course, one of the key requirements of any compulsory purchase order is that it must be the exercise of a last resort. You can only acquire compulsory if you can demonstrate that you're doing so as a last resort, that all reasonable efforts to acquire by negotiation have failed. So clearly you need a surveyor or somebody else who's carried out those negotiations, who can demonstrate by virtue of some kind of audit process what efforts have been made to acquire, what efforts have been made to relocate, what efforts have been made to address concerns that a particular occupier may have, typically a commercial occupier, about what arrangements will be made, what options there are to remain in occupation for short periods. Can they give you a not before date? I.e., have you offered to a commercial tenant an arrangement which means that we would promise not to acquire the land before a specific date, even though that may be sometime into the future? So that is very important. You have that person on board early, because these days, the extent you need to demonstrate what efforts have been made to address landowners' requirements and sort to address them in advance of making a CPO, and whilst the process continues, because there's a continuing obligation to negotiate, is really important. So a surveyor on board early on, or somebody that deals with valuation, is really critical. And then finally, legal input. You will need legal input because you will need someone to assist in the preparation of documents like, for example, the statement of reasons, all of the statutory notices, check and make sure that the referencing agent's doing the right thing. And then, of course, there may be an inquiry, so you'll need advocacy services, potentially counsel, depending on the complexity of the CPO. So yes, it was quite considerable legal input as well. So they're the key parties that you're likely to need. Referencing agent pretty early on, and surveyor very early on. Legal input possibly later. But as I say, the buy-in is absolutely critical from the authority itself. So how do you go about the process of making a CPO? Well, it's not a simple exercise of simply making the CPO, because you're going to need to go through a process of working out why you need to make a CPO. These days, there is a obligation contained within the policy guidance to have a far better and well-organized approach to deciding that you need to make a CPO. There's an expectation, as I said on the last slide, that efforts have been made to seek to address issues about relocation and other matters. And this is becoming more and more important, and that there's an emphasis on showing that you've gone to great lengths before you even consider making a CPO to consider what steps can be taken to address concerns of landowners. Can I relocate? Am I going to get relocation expenses? how much will I get, what likely compensation I be entitled to, what offers are available to me, where can I relocate to, all of that sort of thing. You're expected to go to some great lengths to attempt to demonstrate you've done all of those things before you even get to the first stage of making an in principle decision. So what do you need to do? Well, in making that decision, and when I talk about an in principle decision, what we're talking about is taking a report, usually to your council's executive, your cabinet, whereby you ask the authority that you've gone through a lengthy process of attempting to negotiate. You have a site that you seek to assemble for whatever purpose it might be, for development by the authority itself, or it might be in conjunction with another third party. And what you're looking to do is you need now to exercise CPO powers because you've been negotiating for many months. You have been unsuccessful to acquire by agreement, and it looks as if there's some kind of impasse, which means that you simply can't proceed unless you can acquire compulsorily. So then what you need to think about then is well, what steps do I need to take in order to get me to the next stage? And those steps typically are some kind of direction, as it were, or a decision made by the council to, in principle, compulsory acquire land, in principle, to establish that the land needs to be CPO'd. So normally you would identify the power in that decision, as to, or not in the report that forms the decision, i.e. what CPO power am I going to use? Typically it will be, for local authorities, Section 226 of the Town and Country Planning Act 1990, or indeed Section 17 of the Housing Act. They tend to be the key ones, but planning more than housing, for reasons I'll mention in a minute. And as I say, you need to establish that you've gone through a process. But one of the reasons why you might also want an in principle decision is it's a way of ensuring that you've got the necessary authority to go ahead and appoint a referencing agent. Also, of course, it's a way of ensuring that you can then authorize the process of preparing a draft statement of reasons, which is what you'll need for the purposes of the second decision, which I'll explain what that is shortly. It's also a way of identifying what land you'll actually need. Are there any ways in which you could acquire some of the interest that aren't necessarily involve using CPO powers? So, for example, if the authority is the landlord, could it rely on landlord and tenant powers rather than, say, using compulsory purchase powers? You also want to identify all of the interests that are held in the land. So it's all very well having a plan showing, say, an outline of a town centre, but what's important is understanding what the ownerships are. And for that purpose, what you'll need to do is you'll need to issue requests for information, and ensure that these are answered. You may want them to be statutorily backed. So, for example, Section 16 of the Local Government Miscellaneous Provisions Act 1976 empowers local authorities to require landowners and occupiers of land to provide information about the nature of their ownership for a defined function of the authority. It doesn't have to be for CPO exercise of CPO powers, but that's what Section 16 does, and that means you can serve a notice, and if someone doesn't respond with the information that you've requested within 2 weeks, you can prosecute them. I think everybody appreciates that's not something that happens very often, but it does occasionally, and it's a way, however, of primarily showing that you've gone through a process, a due diligence process of working out who owns what, and that you've got this neat file of responses or non-responses, as the case may be, in response to those notices. There are also provisions under Section 5A of the Acquisition of Land Act which specifically relate to the use of CPO powers, but people tend to use Section 16 as well. And that's a much more generic power, which local authorities use for other purposes as well. The other thing you need to think about when you're coming to compulsory land is, can you actually compulsorily purchase all the land that you have in front of you? So, for example, is there any Crown land? So, for example, premises that's owned and occupied by the Department of Work and Pensions, which I've come across before, is Crown land. You can't CPO that. Land owned by statutory undertakers. So, where land is owned or operated by a statutory undertaker as part of their undertaking, so it has to be operational land of some description. So it could be a substation, it could even just be a conduit through which cables run, it could be all sorts of things. That's given a certain special status. You can compulsorily acquire it, but only with the Secretary of State who's responsible for that statutory undertaking's consent. So what you tend to find in relation to statutory undertakers is that you have to enter into some kind of lift and shift type agreement, because in practice you're not going to be able to CPO them, because in practice, because they are a statutory undertaker, they can put a block on the CPO, because the only alternative to getting that consent from the relevant Secretary of State that's responsible for that statutory undertaking is to go through what's known as the special parliamentary procedure, which is not something you're necessarily going to want to do, because it's a kind of House of Lords type process. So that's one thing you must look at. Is there any statutory undertakers, plant and equipment, or indeed are there any cables or anything of that kind which cross the land, which they too have a similar form of protection to the land that a statutory undertaker has. So they're given a special status in the hierarchy of land you can acquire. So Crown land at the top, can't touch that, and then statutory undertakers land, you can CPO it, but it comes with big constraints, and in practice, it's unlikely you're going to be able to do it. And then you have other species of land, like open space land, that has certain types of open space land have a protection afforded to them, and also consecrated land. So it's worth fully exploring what you have, and this is where the referencing exercise comes in, because it will hopefully show up all of these issues and identify where some of the problems might arise in seeking to develop land. And you will always find on any type of city centre or town centre location that there will be statutory undertakers land, and within that I include telecommunication code operators land and operational equipment. So it's right broad. So we're looking at water, electricity, telecommunication operators, as a long list of potential parties with whom in reality you're going to have to negotiate. You're not in practice going to be able to CPO them. And then there's this extra point, which I think I've alluded to, which is that you could have someone who has some form of statutory undertaking. They have, as I described, some form of right over the land. So it may be the case that they don't actually own any of the land that is affected by your CPO, but they have rights that cross it. So they may have some cables, some overhead cables or power lines, say, that you need to relocate. These are all not known as protected interests. By and large, where you compulsory purchase land that is subject to a right, so it might be an easement, or indeed it might be some form of restrictive covenant, then you will take free of that obligation in return for paying compensation. You'll take free of that unless the land, or unless those rights are somehow protected. And these are known as protected interests. And these are provisions that are contained within section 203 to 205 of the Housing and Planning Act 2016, which makes provision for overriding those sorts of restrictions. And I'll talk a bit about that later, but I emphasize it now because one of the things you want to look out for whenever you're looking at a plan and you're looking at what you want to acquire is what are the underlying rights. So it may be that you don't have a statutory undertaker that has any, say, substations or any leases of any of the land, i.e. interest in the land itself, but what it does have is some right that encumbers the land or affects the land, which you need to address and deal with by virtue of, again, some form of lift and shift arrangement, because not only is their land ownership protected, but also their rights are too. I.e. the rights to lay cables, or the right to may have some kind of way leave over the land. There may be all sorts of different things. The other thing you want to look at is any of the land unregistered. These days, people don't tend to bother too much about trying to establish the nature of an unregistered land ownership. What they tend to do is they tend to treat that for CPO purposes as land in unknown ownership, and then simply acquire it on that basis. That creates a little bit more work in terms of how you approach the process, but there is mechanisms by which you can serve notice on the land, which is in unknown ownership, and you can effectively acquire it. So it's a quite useful way sometimes of acquiring interests which you're not entirely sure who owns, and it's unlikely you're going to establish who owns it, and in fact it doesn't really matter. So for example, when it comes to highway subsoils, you don't know land beneath a highway often who owns it. There is the median principle, which asserts that the landowners on either side have a legal presumption of ownership up to the midpoint of that particular highway. But in practice, it's only a legal presumption. So clearly, if you have any doubts about who owns land beneath, say, a public highway, then you could compulsorily purchase it as a subsoil. Now, you might say, why would you want to do that? Well, of course, the reason you do that is because if it ever stopped up, then any underlying rights would literally come to the surface. And so therefore, if there's any doubt about ownership, you want to resolve that. So this is one of those opportunities where you might want to acquire land that is unregistered because it's a subsoil and therefore there's no registration, or it's unclear because it's never been registered and so therefore it remains unregistered. Or alternatively, there may be land in unknown ownership because there might be some gap in the title, which in practice actually probably does form part of one of the titles, but for whatever reason was left off the title. That too will be often unregistered. So CPOs can be a useful way of addressing some of these sorts of issues. As I said already, do you need any other questions you need to ask is, do you need any temporary rights? Do you need any temporary rights of way? Do you need to have any oversailing rights? So you can acquire through a compulsory purchase order rights. Sometimes, however, you need temporary rights, say, because you need to use some land as some kind of working space. Unfortunately, the compulsory purchase order system as it currently stands doesn't allow you to acquire land on a temporary basis in a formal sense. So what you have to do is you have to go through a process whereby you effectively look to acquire land and then effectively you hand it back rather than going through the whole process of implementation. But I'll touch on that later. I've mentioned rights interference. Also, you need to establish at this stage how much negotiation's gone on, what steps have been taken, as I've said, ensuring that you comply with the full process of negotiation and CPOs being a last resort. Also, for example, things to consider is specifically in the context of housing is what are you going to do in relation to housing occupiers? You might have to relocate people, so you need to think about that whilst works are carried out and then put them back in. I've dealt with a case like that recently. And also the other issue you might want to consider is also service of initial demolition notices. This is important because clearly people who exercise the right to buy, you'll need to address that potentially if they have exercised it, because they'll become landowners and you have to serve notice on them. So the initial demolition notice is a way in effect of stalling that process and stopping people from exercising the right to buy, usually to allow you an opportunity to acquire compulsorily their interest or require that they relocate, which you've got powers to do under the housing legislation. So this is a useful tool for offsetting or dealing. I only raise it very briefly, but it's a useful mechanism by which you can address that problem. And then the other things you might want to think about is what steps have you taken in relation to procuring a development partner? Is that on the horizon? Clearly, if you're proposing to promote a CPO and it's dependent on a development partner, then that's going to be a critical issue at the inquiry. To what extent is that development partner likely to deliver the project that you're using the powers to promote? The inspector isn't going to be very keen on promoting confirming a compulsory purchase order if it's not clear that the developer either has the financial resources to deliver the scheme or indeed has the track record. So, where are you in relation to that? Have you got somebody lined up? What are their bona fides? All that kind of thing. All important things to consider. And are there any other impediments to the implementation of a compulsory purchase order? This is a key test that an inspector will consider when he's discerning whether or not to confirm a CPO. And what we're looking at here are issues such as, do you need a stopping up order, for example? Is there any legal steps that need to have been taken? And does that create uncertainty around whether or not the compulsory purchase order should or could be made? So consider in particular highways orders and whether you need an order under Section 247 of the Town and Country Planning Act. And also, other measures that you might need. Is there any physical reasons as to why you can't go ahead and promote the compulsory purchase order? Also, consider on a preliminary basis whether or not there are any alternative sites by which or where you could locate your development. And one of the great arguments that any objector can often deploy at an inquiry is to say, we don't need my land because you could deliver your scheme without me, or argue alternatively that somewhere else you could deliver the scheme and not on my land. So it's important to consider that you have a proper good legal basis and that there really is a compelling case. You really do need that piece of land in order for the CPO to be promoted. So you get your, in principle, decision to proceed. You get your approval of your expenditure to go out and get a referencing agent. You can go ahead and serve requisitions for information. You do all of those things at that first stage. What else you also need to consider is, do you have the funding necessary to deliver the scheme? Where is it coming from? How's it being secured? And I've already mentioned that point. And also, I've also mentioned the potential risk once you've made a compulsory purchase order of either some form of, usually a blight notice being served, requiring the authority to acquire the interest. So you go through all of that process. You get your initial in principle decision. You go off, you employ your referencing agents. They go ahead, prepare some plans and maps. They produce a schedule. What do you do at the same time? You prepare at this stage usually a draft statement of reasons. Draft statement of reasons is important because although it's a non-statutory document, it's very important when it comes to promoting a CPO, because it's effectively your case and it's a requirement of the policy that you provide a statement of reasons to the Secretary of State, and also serve copies on all of the parties who you serve the compulsory purchase order on. So the key things that you're doing at this stage of the process prior to making the final resolution to proceed with the CPO, having made the in principle decision, is the draft statement of reasons, CPO schedule and CPO map. The draft statement of reasons is critical, as I say, because it's your case that you're using to rely upon. And indeed, that will be the basis upon which you will allow or require the final in principle decision to be made. Other things that often are considered at this stage is, do you need to appropriate land to a planning purpose? There may be some land within a site, say a town centre location, again, which is owned by a local authority. It may be encumbered, as I said previously, with rights. It might be a restrictive covenant affecting the use of the land, which interferes with the proposed use as per the CPO. So the question you might want to consider is, well, should we appropriate that land to a planning purpose while the council is still the owner, and also tie it up with the CPO? If you do that, as I said before, you can take advantage of sections 203 to 205 of the Housing and Planning Act 2016, which allows you to override the restrictions that those impediments or the restrictive covenant imposes on the use of the land, in return for paying the person that benefits from that right some compensation. But the useful thing is, it means you can go ahead and develop, and therefore there is no injunction risk. And it's a very useful tool that can be used quite creatively in a number of circumstances. So what powers do you need to think about when you're promoting compulsory purchase orders? As I've said, the key one is the Town and Country Planning Act power, section 226 of the Town and Country Planning Act, which enables acquiring authorities with planning powers to acquire land if they think it will facilitate the carrying out of development, redevelopment or improvement or regeneration of land. And that by doing that, they will promote the economic, social, or environmental well-being of their area. It is the most well-used of powers that local authorities use. It's probably used, I think it's used in something like 60 or 70% of all cases. And it's quite flexible, and it's one that does what it says on the tin. Another power that's regularly used is the Housing Act 1985, Section 17, empowers local housing authorities to acquire land or houses or other properties by compulsion for the provision of housing accommodation. However, policy guidance says that the acquisition must achieve a quantitative or qualitative housing gain. So this is a much more specific type of power, and it's very much focused on the provision of a thing, housing, whereas the Town and Country Planning Act is really much broader and simply looks to much broader outputs. Arguably, if you have a scheme which is dominated by the provision of housing, you'd be sensible to use the Section 17 power, the Housing Act power, because in practice, as long as you can show a quantitative or qualitative housing gain, it's easier to establish, whereas the Town and Country Planning Act is broader. Now, there's often a debate, and there's also the Highways Act, but I won't go into that. That's obviously specifically for highways, and that's dealt with slightly differently. So how do you decide, say, as between the Town and Country Planning Act 1990 and the Housing Act 1985, which of those two should you use? You might have a scheme that has housing, but also certain mixed uses as well. Well, the guidance is reasonably balanced, and it effectively says that the inspector, if he determines or she determines that one of the other powers is more appropriate, will actually look at the criteria for that power in determining whether or not to confirm the CPO. So let's pretend you promoted a CPO under the Town and Country Planning Act 1990, but there were significant housing elements, then it's likely that the Secretary of State would look to see whether or not there were quantitative or qualitative housing gain as part of that exercise. So it doesn't actually matter which route you take. You just need to be alive to the possibility that an inspector might take a broader approach than you think they necessarily should if you assumed that you were pursuing a CPO under, say, Section 17, but in practice there are wider considerations. So I think you just have to be quite pragmatic about it. There isn't going to be a very rigid statutory approach, which is because the obligations for using the Section 17 power, looking at quantitative, qualitative housing gain, that you're never going to have any aspect of it that isn't going to bring in some of the requirements of the Town and Country Planning Act 1990. Now, to assist you in all of this, and then there is a set of guidance that's called the Guidance on Compulsory Purchase Process, which was published in October 2024. Now, this is the latest incarnation. I think it's about the fourth or fifth iteration of this form of guidance, which I think was originally published a while ago. And I think you can't underestimate its importance. The guidance is effectively a kind of black letter law in reality for making and promoting compulsory purchase orders, and that every word is relevant. So you'll often find, if you deal with counsel, that they will treat each word of the guidance as if it were a black letter law. So I think that it's probably one of the most important documents to get your head around. It's an interesting document because it covers all sorts of things. It covers principles around what steps you should take in relation to offering prior to making a CPO, and what efforts you've made in order to demonstrate that there's a compelling case and that the CPO is being used as a last resort. And then at the other end of the extreme, it provides a form of checklist for what goes into a statement of reasons. It lists who you should contact to confirm a CPO, and it deals with provisions around compensation. So it's a very, very broad document, but to its credit, it is actually quite well written, and it is quite easy to follow. But it isn't the sum of everything, but it is a very, very useful guide, and it's absolutely critical for the purposes of for the process of the procedural aspects of making a CPO, because it's very good at summarizing what are some complicated statutory provisions. I've already discussed the point about which pen to use. Yeah, as I say, one of the issues that's contained, however, and I may emphasize this in the revised CPO guidance, is that a far greater emphasis now is made on front loading the approach that acquiring authorities are supposed to take in the context of making compulsory purchase orders. And what by that I mean is that they really are required to take a far more consultative approach, dealing with potential affected parties and really getting to grips with how they can possibly assist parties without making a CPO, or how they can accommodate them even if they have to make a CPO. So as I say, there's a very, very strong emphasis on consultation, and there are a key set of steps now that acquiring authorities should take, which is set out in paragraph 19 of the guidance, which sets out in clear terms what's required. I've got a question, but I'll take the questions at the end if I may, if that's okay. But anyway, there we are. So as I said, the key test to making and confirming a CPO is the compelling case test. Now, this should be considered at 2 stages. When an authority resolves to make a CPO, it's supposed to apply the compelling case test and also consider human rights issues and also its public sector equality duty. When an inspector makes a decision to confirm a CPO, a similar exercise is followed. So there are, in effect, it happens twice. So that's why local authorities have to be very confident when they resolve to make a CPO that they have the necessary powers, that they have followed the appropriate guidance, and they can demonstrate that the use of the powers is being used as a last resort, and that they've considered properly the human rights angle, and that the CPO is fully justified, and that there's centrally, of course, a compelling case in the public interest. Now, the guidance doesn't actually say what a compelling case in the public interest actually is. All it simply says is that the public benefit should outweigh the private harm that's caused by the making and promoting of a compulsory purchase order. And of course, each case will turn on its own facts, and what you need to demonstrate will be determined by the case you're dealing with. So it doesn't go much beyond that, simply by saying you need to demonstrate that there's a strong public policy reasons as to why someone's land should be taken from them. And that echoes human rights provisions, which effectively say that it's entirely legitimate for a public body to acquire an individual's land, assuming it's done in the context of a democratic society, and that you can demonstrate on the balance that the greater good will be served by acquiring land, and that the harm caused will be the absolute minimum necessary to achieve that objective. So that's why CPO is permitted from a human rights perspective. Public sector equality duty, again, is a bigger issue and gets bigger every time, becomes more and more prevalent and important, and it's something you simply can't ignore. Irrespective of the nature of the CPO you're making, you must fully consider the council's public sector equality duty and carry out some kind of EQIA, even if it is to establish that no one is affected at all by the proposal. There's no one with any protected characteristics is either likely to be directly or indirectly affected. You still have to go through a process of demonstrating that that's the case. So it's an absolute essential that you go through some form of equality impact assessment to establish whether or not anyone with protected characteristics is likely to be affected by the proposals. And if you think there is a possibility, to what extent you'll attempt to address those problems. It isn't an exercise of trying to solve those issues, it's simply to identify them and then seek to address them. But if you haven't gone through the process of seeking to identify them in the first place, it's going to be very difficult to be able to establish whether or not you've taken steps to resolve them. So that's why carrying out some form of public sector some kind of equality impact assessment is absolutely essential on every CPO. And in fact, it becomes increasingly the case. So every CPO I deal with, even if it's a town centre, which just involves, a row of shops, there should be some form of EQIA. I said I'd mention section 203 to 205, and I'm just recapping really. What this does is it allows local authorities to override and in fact developers who acquire land from local authorities who have the benefit of the section 203 to 205. What it does is it allows them to override any restrictions on land. So this deals with things that affect the use of land. So it could be restrictive covenant, not so much easements because they're dealt with under the Town and Country Planning Act, although outside of that, this would deal with those. But things like rights to light, for example, that would be a way of dealing with it. And what this does is where land is in the ownership of the authority, the local authority has an interest in the land, they can appropriate that land to a planning purpose, or indeed if they acquire it compulsorily or by agreement, they will, for the purposes for which there's planning permission and it's required, they will override those rights. I use the expression override because it is a temporary fixture. The intention is that the override would only apply for the duration of the time that the use is needed for that purpose. But anyway, what it allows you to do is that where planning consent exists for the operational use of, for the use or operational development of the land, and the local authority has acquired that land, or if it already owns it, appropriated it to a planning purpose, then the local authority has the right to override that then it will override any restriction on the use of that land, which would affect the carrying out or use of it for the purposes for which planning permission has been obtained. So it's a very useful tool because it deals with circumstances where a local authority owns land and therefore in theory can't CPO it, but it can address issues that relate to how a right affects the use of that land. And compensation, as I say, however, is payable, and it's calculated by working out how the beneficiary of the right has their own land diminished. So compensation isn't paid on the basis of ransom value, it's based on the basis of the extent to which the land that benefits the right is diminished. Very useful tool, used quite extensively these days, has always existed in one form or another, but in lots of different statutory places. For those who have long memories, Section 237 of the Town and Country Planning Act addressed a similar issue, although there was always debate about the nature of the override in those contexts. But it was always an override. What these provisions have done is effectively codified the common law and updated the statutory provisions. In terms of compensation, it's payable by the party who interferes with the right. So if the local authority acquires land for a planning purpose or appropriates land for a planning purpose and then disposes of it to a developer, if it's the developer that carries out the development or in theory interferes with the right, it is they that pay the compensation. But there is an opportunity if they don't pay for the claimant to seek compensation from the acquiring authority. So it lands in the lap of the acquiring authority eventually, even if not in the first instance, assuming the developer doesn't pay. One thing to consider sometimes, I mention this primarily because I've used it, Landlord and Tenant Act 1954. Clearly there are occasions where land, where the council say is the landlord, and it has tenants under the 54 Act. Clearly they have the benefit of protection under the 54 Act, and compensation is payable to those parties where the authority wishes not to extend or a lease, because otherwise it will automatically continue. And if they can demonstrate they have a firm and settled intention to develop, then they can effectively bring that tenancy to an end. Now, sometimes, of course, they could also CPO that interest. Now, clearly, of course, if the tenancy has a long period to run, then this isn't going to help you because the 54 Act is only assists or is only relevant when a tenancy is coming to an end. But say pretend, for example, a tenancy is due to expire, then it might be the authority might think that actually it's more practicable to use the Landlord and Tenant Act rather than CPO powers. And the reason for that is because under the Landlord and Tenant Act 1954, there's a maximum of 2 times rateable value compensation for bringing that tenancy to end where a landowner has a firm and settled intention to redevelop. However, using CPO powers, the compensation could be significantly more. So sometimes it's tactically a good idea to look to see whether or not, in relation to land, the council is the landlord of what options there are for using those powers, because it's strongly advised that that's a better solution potentially. Briefly on Planning Act CPOs, because they're so common, these are the sorts of things that you need to demonstrate for the purposes of promoting a CPO. How the proposals you have fit within the local plan. How does the proposal contribute to the achievement of economic, social, and environmental well-being? Could the outcome be achieved by any other way? What's the financial viability? They're things that specifically the guidance touches upon, and they the sort of things your mind should be drawn towards. So let's pretend, for example, that we now get to a position where we've gone through a process, you've had an in-principle decision, you've gone through an exercise, you've appointed a referencing agent, they've produced a plan, they've produced a schedule, you've prepared a statement of reasons, draft statement of reasons, you've gone to your second full decision of cabinet. They have determined that they're quite happy for the compulsory purchase order to be made. Now, what will you put in your sorry, no, hang on. Yeah, you go through that process, and so therefore there then have followed, after you've made your final decision, you've made your compulsory purchase order. what you're going to have to put in your witness evidence, what follows after that process of having made the CPO. Well, once you've made a CPO, then what then follows is a process that leads you to inquiry, which I'll talk about. But one of the steps you have to take is prepare a statement of case, which is your statement of reasons effectively in another form. And that's why it's important that you contain within your statement of reasons a comprehensive case as possible, because of course it then helps you with your ultimate statement of case. What I've listed there is the sorts of witness evidence you might need, and also to emphasize that it's a long and detailed process, which I've already touched on before, but it's really about the buy-in side of things, and what the kind of evidence you'll need. And these are the sorts of things you'll need to do to demonstrate that it's quite an involved process. So as you lead up to an inquiry, you're going to have to deal with all sorts of things like preparation of evidence, bundles, and all the rest of it. But I'll come back to that in a minute. In terms of the form of order, what I've done is I've simply illustrated on the next slides what these things look like and what a referencing agent will produce and what the order needs to cover. So it needs to cover land ownerships, and it does that in what's known as Table 1. And then in Table 2, you have third-party interests. So effectively, these might be mortgagees' interests or others, or restrictive covenants that affect the land. And then 3 will identify new rights, i.e. this is where the authority wants to acquire a new right to do something. So it's not to acquire land, but it's a new right. So it could be, say, a right to oversail a crane over the site, etc. And this is what those schedules look like. You can look at these at your leisure. These are taken from some old CPO guidance, so they don't actually disclose any confidential information. And they're just illustrative of what it looks like. That's roughly speaking what a plan looks like. The colors have gone a bit weird. Normally, those areas shown in weird kind of brown color would actually be pink. And there you illustrate the kind of, and then the bits in blue illustrate where only rights only to be acquired. And the idea of this is to illustrate very clearly on a map, which has to be to scale of 1 to 1250 as a minimum, what needs to be acquired and where you want to acquire rights. So that is the sort of rough plan of what it looks like. As I say, the areas in blue demonstrate areas over which rights only are to be acquired. So we've gone through a long process, which I've explained. We've made our CPO. What do we do after we've made our CPO? So we've got this document in front of us. It's sealed. The schedule's sealed, and the order, which forms part, which the schedule attaches to, is all sealed. We've got all the copies we need in front of us. What do we do next? Well, what we have to do then is we have to serve on all of the qualifying persons, and that's basically anyone who has an interest in the land or would potentially have a right to compensation in the event it got there. You have to serve a statement of reasons and a thing called a notice of making. You have to place documents on a website so that people can access them electronically. That's a relatively new requirement, although authorities have done it for some years, but it's now a mandatory requirement. You also have to physically put the documents on deposit so people can come and have a look at them. And I say you send copies of the sealed and unsealed copies of the CPO and map, statement of reasons, and a thing called the general certificate and the protected asset certificate to the planning casework unit. Planning casework unit processes compulsory purchase orders on behalf of the Secretary of State for the Ministry of Housing, Communities and Local Government. They're effectively a government, they're like the old government office in effect, and they're based in Birmingham. And they process it, and they will determine, they will then refer the matter to the planning inspector if it's a planning CPO, and indeed if it's a housing CPO. But if in other circumstances, I think it's probably who they go to. So what then follows is that you then sit and wait, and you wait for objections. As I said before, a local authority can't confirm its own CPO unless there are no objections, but it sits and waits. You have to give a minimum of 21 days for people to object. So you tend to wait. You usually have to wait about 28 days to see if there are any objections. Typically, there will be some. And you then wait for the Secretary of State, or rather the Planning Casework Unit, to contact you to tell you how the process is going to continue. And they do that by sending you a reference letter. And what this does is it has a reference date in it. And that's, one of two things will happen. They either send you a letter, which is a reference letter telling you there's going to be an inquiry, and then it sets out the timetable of what needs to happen. The first step in that process is the authority has to prepare a statement of case and serve and file it within 6 weeks. If there are no objections made, then the Secretary of State will effectively permit the council to confirm its own CPO. but that doesn't always happen. So if there have been any relevant objections, then it's likely a CPO will be called. And then there's a commitment in that letter to convene the start of an inquiry within 21 weeks of the date of that letter. That letter effectively triggers the process for making for progressing to an inquiry. So what do you have to do to prepare for an inquiry? Well, as I said before, you need to determine how many witnesses you need. Typically, something like 4 or 5 is not unusual, and that's some kind of overarching planning one. A planning one, an overarching counsel one, a surveyor and developer if there is a developer on board, to support why the scheme is going ahead. So that's 4. There may be others depending. Each of those witnesses has to produce a proof of evidence. They also have to produce a summary, which is the thing they actually read out, a bit like a planning inquiry. And these must be filed and served within 3 weeks before the inquiry. As I say, once you get to that stage, things get very frantic. You need to prepare an inquiry bundle, which is usually pretty voluminous, and includes all of the counsel's evidence and any evidence which the objectors have produced, if they have any. And then, of course, you have to deal with, in that 3-week period, you'll deal with rebuttal evidence. So what happens is you serve evidence, and then the objector will come back with additional evidence, which you will then want to rebut, or you may not, depending on what you want to do. There's no obligation to rebut evidence, but sometimes it's good to get your case in. And as I say, and then at the same time, you're often dealing with negotiating the withdrawal objections because you've reached agreement with some of the objectors. So it's a very, very busy time usually, and there's a lot to do, and it's pretty frantic. At the same time, you're also preparing for an inquiry, so it is very frantic. And then at the inquiry itself, typically presided over by an inspector. These days, typically the inspector is the party who will make the decision, because of course of this new approach to giving delegated powers to inspectors to resolve decisions. It's conducted very much like a planning inquiry. As I mentioned before, there's an opportunity for the counsel to present its case, opportunity for the objectors and the inspector to cross-examine the counsel on its case, then an opportunity for the objectors to give their evidence, opportunity for the counsel to cross-examine, inspector ask questions, and then finally an opportunity for closing statements to be made. There's usually a site visit as well that follows, etc. As I said, pretty voluminous inquiry bundle needs to be produced. So that again it is pretty intensive on the document side. It is actually pretty voluminous when it comes to it, because in that bundle will be the council's original decision to make the CPO, statement of case, statement of reasons, the evidence, any of the documents that are referred to in the statement of case and statement of reasons. So it soon builds up. And as I say, any other information that's been provided. So you then have an inquiry. It'll last as long as necessary for the purposes of hearing the evidence. Even if you've got a couple of objectors, you may end up with a 2-day inquiry. And then after the inquiry, the Secretary of State, or more likely these days, an inspector, will make the decision. As I say, these days, because it's made by inspector in most cases, or a lot of cases, you're likely to get a decision more quickly than you did historically. They will decide whether to confirm the CPO. Assuming they do, then the council must publish confirmation of the CPO within 6 weeks. And the date of publication triggers a further 6-week statutory challenge period. Along with publication of that notice, they must effectively serve that notice on all qualifying persons. So it's effectively everybody that was served originally. Again, quite a laborious exercise. Publish a press notice and publish a site notice. And again, there's an obligation to upload the notice onto your council website that you've set up for these purposes. And finally, don't forget there's an obligation to notify the Land Charges Department of the authority that the compulsory purchase order has now been confirmed, because it's a local land charge for those purposes. It's something that sometimes is often forgotten. So what do you do to implement a CPO? Well, you've got your nice shiny CPO. You've gone through a process of advertising it. You've sat out the 6-week statutory challenge period. No one's objected. So what do you do at this stage? Well, you've got 2 options. you can either serve a general vesting declaration or make a general vesting declaration and then serve it, or serve the notice of the fact you've made it. And what that does is that once in a period of 3 months has elapsed, you can then effectively determine a date upon which the land will vest. So it's the cleanest and easiest approach, although it doesn't apply to, or it can't be applied to minor interests, i.e. that minor interests determined to be interest of either 12 months or 12 months to run. So it's effectively short leases it doesn't apply to, or other types of occupation. But it's a very useful means by which you can get title if you need it, and often dealing with town centre type regeneration projects, this is the model that's most used because a developer will want ownership up front. Alternative to use of that process is this process called the notice to treat, notice to enter. What this does is it effectively allows, by virtue of a notice to treat followed by a notice to enter, allows you to gain occupation of the land, but ownership doesn't pass until compensation has been agreed. So it allows you to, on a statutory basis, to permanently occupy the land until that happens. Once compensation has been paid and agreed or determined, then the acquiring authority has a statutory power to require that the vendor transfers the interest to the council. Usually what happens is that some form of agreement is reached in relation to compensation and there's a formal transfer. The key differences between them is that a general vesting declaration, you must vest the land within 3 years of the operative date. And the operative date is the date that the compulsory purchase order is, the confirmation of which is first advertised. So you've only got a 3-year window in which to vest the land, which potentially can be a bit of an issue depending on the project you're dealing with. Notice to treat is a bit more flexible. As I say, this doesn't actually get you ownership of the land, it just gives you a statutory right of occupation. And what that requires is that you can serve a notice to treat, which is the first step in that exercise, and that's valid for 3 years. And then what you can do then is serve a notice to enter, which it too, you have to have exercised the right of entry within 3 years. So it gives you a bit longer than the initial 3-year period. So if you do have time constraints, it's quite a useful tool. In both cases, you have to give 3 months notice for the operation of the process. In all cases, you give it 3 months. The landowner has an opportunity, if they wish, to serve a counter notice to bring that date a bit sooner, if they don't want to wait 3 months. So there's a kind of opportunity to serve a counter notice in certain circumstances. So it doesn't, they don't always have to wait, but if there isn't, that notice isn't served, then the minimum of 3 months has to be elapsed. And compensation, which is sort of coming more towards the end of the process, as I say, you've served your notice to treat or you've gained occupation and the land is vested, then the trigger date for the entitlement to compensation is the date with the notice to treat, date of entry for the notice to treat process, notice to enter process, and the date the land vests where you're dealing with a general vesting declaration. And compensation, broadly speaking, looks to try and put the party back into the position they would have been had the compulsory purchase order not been made. And this is known as the principle of equivalence. And what that does is it looks at a number of different factors. So it'll look at the market value as of the date of vesting, because that's the key date for compensation purposes. And it will look to see what planning permission might have been obtained, what may have happened, and try to come up with a valuation which reflects both an inherent value of the land and what it could have been used for, which is known as hope value. And that's effectively its market value on that date. And that's determined just by crystal ball gazing and looking into the future, assuming a CPO had not been made. And so you park the fact that compulsory purchase order was made, and you look to see what might have happened and how you might have valued the land on that date. That's the basic test for market value. You're also entitled to a thing called injurious affection, where, say, for example, you owned a piece of land and you've retained part, and say the land has 50% of the land has been sold, but it could have accommodated, say, 10. It says hours. It should say homes. 10 homes capable of being built on the plot. 50% taken, but only 3 homes can be built on what is left. in those circumstances, one would say, well, of course, had the land not been acquired, in those circumstances, I'm entitled to the 50% that's taken from me, the market value of that bit. But I'm also entitled to injurious affection because I can't proportionally take the full value of what's left, because it's been diminished by more than the amount of land taken, because the value of 5. So that's injurious affection, the idea that the taken may be affected by, the part that's retained may be affected by the land that is taken, and you should be proportionately compensated for that. And also you're entitled to things like disturbance compensation. This applies in a very important way in the context of businesses, because if a business is displaced, it's likely to have costs, so have to relocate, will need to reprint its business cards, move equipment. It's quite an expensive process. And in certain circumstances, a business might be able to argue that it simply can't relocate because it can't find anywhere else to go. In those circumstances, it may be entitled to argue or assert business extinguishment compensation. And that means that you're not only going to have to pay for the cost of value of the land, but also potentially for the termination of the business, which might mean that you have to pay, say, 3 or 4 years net profits, for example, for a small business, which is another on-top cost. And then finally, you've got some statutory bases for compensation, home loss payments in the context of residential accommodation, which is an extra 10% up to a I can't remember what the statutory maximum is, but it's about £4,800 or something of that kind, but up to 10% of the value of the property. And then on commercial property, you've got this thing called basic lock and occupier's loss payments, and that's up to a maximum of £100,000 in total. And basic loss relates to land ownership. Occupier's loss relates to the loss caused to an occupier, because it may be that there are 2 different parties there. And the basic loss would go to the landlord, and the occupier's loss would go to the tenant. And in those circumstances, I think the occupier's loss is 25% and the basic loss 75%. But they're looking to change that polarity. But anyway, so there's an extra element of compensation. Total amount available is up to £100,000, assuming the value of the land is no greater than £1 million. If it's greater than that, you still only get a max of 100,000. Compensation, the limitation period for bringing claims. So let's pretend land has been acquired from you, have a vesting date. Then if you're a claimant, you've got 6 years from that date in order to refer the matter to the Upper Tribunal Lands Chamber if you can't resolve it by agreement. So there is a relatively tight time frame, and it's amazing how quickly time can elapse if you are a claimant. And sometimes acquiring authorities rely on that, knowing that after 6 years they'll be immune from having to pay. Interest is payable based on a relevant statutory rate from the valuation date, and the valuation date is the date of vesting, say, or occupation of the land is taken, the compensation trigger date, and that is calculated based on, it's not on a compound basis, it's a straight line basis in a set amount, depending on where the Bank of England base rate is. So currently it's reasonably generous, although for about 5 years at least it was 0 because interest rates are so low. Claimants don't necessarily have to wait until the end of the process to get their compensation. There's an ability to apply for an advance payment of compensation, but this is only ever 90% of what the acquiring authority assesses the compensation to be. So it's usually much less than the claimant thinks they're entitled to, but is payable in most cases, other than where properties have very high mortgages. So it's a useful tool for a claimant if they want to get some money up front. And so therefore that's something that they're often recommended to do. In terms of anything new coming up, there are a few changes in the system. There has been a couple of tweaks here and there. The Planning and Infrastructure Bill, which was published last week, allows for electronic service of documents by email, assuming it comes into force, where the party has agreed in writing to receive those documents. This would be a huge benefit going forward. I think some of the requirements to serve documents can be pretty onerous. If you're dealing with proofs of evidence, you're having to serve all of the objectors with the full set of proofs. You can be dealing with hundreds and hundreds of pages of documents. So yeah, this would be useful if it could be implemented. Although it's dependent on someone agreeing. So I mean, clearly, if you wanted to be particularly awkward, you could simply not agree as an objector to receiving those documents, and then you'd be entitled to them in hard copy form. You put the acquiring authority to the maximum amount of trouble. There's also potentially a new power to modify CPO at confirmation state, i.e. by the acquiring authority. Currently, that's only something that the Secretary of State can do. And there's also a proposal for an expedited GVD procedure, which allows a shorter time period for vesting. Currently, as I've said, you have to give 3 months notice of vesting taking effect. The suggestion here is to reduce that to 6 weeks, so half the time. And this would be in circumstances where property was in disrepair, was contaminated, there was risk to health, or is unfit for its ordinary use. So that's an interesting change. I don't know quite what problem that seeks to address, but clearly it's one that the government thinks is worth addressing. And then there are other changes to the Planning and Infrastructure Bill coming through. There's a provision to allow for vesting by agreement. It's quite a handy idea. So rather than having to sit out the full 3 months and wait for vesting to occur, the recipient of the vesting order could agree effectively an earlier date for vesting. That might help to speed things up a bit. As I said, the basic loss and occupiers' loss payments process is going to change. Currently, basic loss is 7.5%, and occupiers get 2.5%. So it'd be 75,000 and 25,000, reaching 100,000 if you're both an occupier and an owner. It's 100,000. This is going to switch because it's felt that the owner should get less and the occupier should get more. So there's an intention to switch the polarity on that. Also, of course, they're proposing to introduce provisions around no home loss payments in circumstances where it should be Section 215, sorry, of the Town and Country Planning Act. So that's powers under the Act to deal with properties that are causing some offence to amenity. Local authorities can serve a notice under Section 215 of the Town and Country Planning Act 1990 to require someone to tidy up their property. Where notice has been served under that provision, or the Housing Act when you're dealing with dangerous properties, or indeed where you're dealing with listed buildings, where listed building repair notice has been served, no home loss payment will be made potentially in those circumstances. So the idea is to try and not reward people by giving them an extra sum of money by virtue of the fact you're taking steps because the property is in disrepair or there's something else. So it makes a lot of sense. But again, I'm not necessarily sure how much of a problem that really is. And then we still have a hangover from the Leasehold and Reform Act of 2023, which there are a number of provisions that are yet to be implemented. So, for example, there is a provision under the Act to remove entitlement to hope value where, for example, a local authority is proposing to build social housing, and the argument there is why should a developer get the benefit of private sector housing or the potential for private sector housing as a compensation when all that the authority is looking to do is provide public housing. There's a process by which you'll be able to remove an entitlement to that kind of compensation, which is intended to try to encourage landowners to agree lower valuations and therefore sell land, or alternatively to try to recognise the fact that there are certain circumstances where the public purse shouldn't be compensating on that basis. I'm not entirely sure I agree with all of that. I think ultimately land has a certain value and seems a bit unfair to be effectively expropriating value because it's being used for a public purpose. But I mean, that's the nature of the provisions that we have. And then there are also other streamlining of the CPO process generally. There's some proposals, or there are proposals contained in that act and also in the Reform Act, sorry, in the Planning and Infrastructure Act, which deal with shortening judicial review periods to try to ensure that they are aligned with periods contained with the Acquisition of Land Act, also potentially to take away some of the grounds that people currently use for judicial review to challenge compulsory purchase orders. So there's a range of small changes, but none of them, it seems to me, amount to very much really in terms of wanting to speed up the process, because I don't think there are many measures you can take to speed up the process. But anyway, that's where we are. So that is an incredibly speedy canter through making and promoting compulsory purchase orders. And I have a question I see. Let me just see what it says. Yes, interesting question. If using Section 17 of the Housing Act power to make a CPO, can you still rely on Section 203, the Housing and Planning Act, to override rights, given that it requires land to be acquired for a planning purpose? I don't think that's strictly true, actually. It doesn't say it needs to be acquired for a planning purpose. Appropriation has to be for a planning purpose. It simply says it has to be acquired for a purpose for which the authority could compulsorily purchase the land. So if you can compulsorily purchase the land under Section 17, then you could do it, but you couldn't use it if the council already owned the land and wish to appropriate it. So if it acquires it under Section 17 compulsory, then it can rely on Section 203. But if it already owns it, then it has to be appropriated to a planning purpose, because that's the only way you can deal with it. And that makes a lot of sense, because fundamentally, under the old law, or the law as it's always existed, Parliament has always presumed that where a statutory provision allows you to compulsorily acquire land, what comes with it is an entitlement to override any rights affect that land. So if you ignored, for example, the use of, if you remove from this exercise the planning CPOs, and using housing CPOs, then the assumption is that you will override. So what this Section 203 is effectively doing is it's confirming that position, because it was only really under the planning legislation where you could address specifically rights, because it was Section 237 that effectively allowed you to address the issue of rights. So it seems to me that, yes, that must be the answer. So I think the answer to your question is yes, but because it doesn't have to be for a planning purpose. It has to be acquired for purposes for which there is planning consent, but it doesn't have to be for a planning purpose. So you can rely upon Section 17. But anyway, that's my answer to that question. So I think, unless anyone's got any other questions, any questions from anybody out there? No questions? We will be providing the slides, so don't worry about that. They'll come to you. Also, could you do the feedback form? That's really helpful to me and us in determining the sort of things that you'd like us to cover. And if there's any other questions you have, or if you have any questions you'd like to raise with me direct, then please feel free to contact me. I did say I'd allow 10 minutes for questions, but I'm not sure they're needed. So anyway, thank you all for attending. As I say, please complete the feedback form. And as I say, the slides will be sent to you by my colleague, Julie. Oh, more questions. Hang on, there's a chat question. Okay, yes. Thank you. That's it. That wasn't a question at all. It was just a chat comment. So, Julie, I think we may as well wrap it up. Are you there somewhere?
Yes, thank you, Nathan.
Thank you.